The production of this show is made possible by the support of viewers like you. Please visit conversationsthatmatter.tv and become a subscriber. Welcome to Conversations That Matter. Each week we look in depth into an issue that is shaping the future of British Columbia. Today we are returning to land claims, an issue that could be one of the most, if not the most important issue of the next half century. Joining me now is correspondent Mike McNish. Mike, who do we have on the show with us today?
Former Attorney General of British Columbia, Geoff Plant. He's also a widely respected legal mind in British Columbia and Canada. You know, he sat in the Attorney General's chair, so he's acutely aware of the challenges and the opportunities of the government working with First Nations, as well as the complexity of First Nations and their land claims.
And from his perspective, he, like Gordon Gibson, believes that this is a significant decision. It's not just business as usual, that this has changed the way that we're going to function going forward.
That's right. And Geoff Plant is someone to listen to in terms of, okay, yes, this is a game changer, but now what do we do? How do we move forward? And there's lots of questions. But I think one thing that is becoming clear, and it'll be interesting to hear Geoff Plant talk about this, is even in the original court decision, Justice Vickers here in British Columbia said, if we depend on the courts to resolve First Nations land claims, you've missed the picture. You're missing the opportunity to actually get things done because it just won't work. It'll take forever and it'll be acrimonious. And the second piece that has come out, and I'm sure Geoff Plant would agree with this, government has to come to the table in a more substantive way, particularly the provincial government. And it has to come with a real commitment to work collaboratively in a non-adversarial manner with First Nations. And so we're hearing more and more from the legal minds, the minds on government and democracy, that these are the two key things that are really essential for what's next. And I'm sure Geoff Plant will have lots of very interesting thoughts on those particular issues.
Well, on that note, let's go to that conversation that I recorded with him on August the 18th, right here at La Cigale. Thank you for joining me today. The premise of our discussion is to take a look at the Tsilhqot'in Decision, but really it's what does that decision mean? How is this going to change the way that the province of British Columbia can operate legally in areas that now a band or a group of bands are given title to property? How's the province going to be able to manage that?
Yeah, I think in the first aftermath of the decision, people were trying to understand what it said. The question of what it means is a much harder question that's going to get worked out over time. I actually think people who aren't lawyers could read that decision and understand it, more than just understand it.
Well, Justice McLaughlin was pretty clear.
She's very clear, and she's a clear writer, and I think what she was saying is that this 150-year project of sort of holding our hands back against the idea that Aboriginal title is real and meaningful and exists, that's come to an end. We have to kind of change our approach. We have to get away from what I call denial mentality into a world where we imagine what it would be like to embrace First Nations and their rights and figure out how we can jointly create a province that prospers.
But in her decision, she says this is another step towards reconciliation. Could it not also be a step away from reconciliation, depending on how it's read on both sides of the equation?
Well, it's capable of becoming something that moves us away from a reconciliation. I mean, when she speaks about another step towards reconciliation, she more than most is mindful of the long history, including 40 years of modern Supreme Court of Canada decisions that she might say represented and represent incrementally a step-by-step path towards a legal framework that says you have to take Aboriginal people and their rights seriously. What it means to take them seriously is, I think, an opportunity. 30-odd years ago, this Court of Appeal, in a decision that people still remember, temporarily stopped forest harvesting on Mears Island because there was an unresolved claim of Aboriginal title. Now, there are two things you need to know about that. One, that no logs have ever been harvested from Mears Island. It was a temporary halt that became a permanent halt. But more importantly, we're 30 years into the expansion and development of Aboriginal title in British Columbia, and we still have a thriving forest industry. Why? Because there are some forest companies that have been nimble, creative, progressive enough to figure out how to work on a land base and take Aboriginal interests seriously and still make money. I think that that's still possible.
Well, when you talk to the Business Council of BC, they say, okay, this is another step down the path that was started really with Delgamuukw in our requirement to consult.
Right.
Now it's saying, well, go beyond consultation, get consent. But they say it's down the same continuum. Gordon Gibson says, no, this is a game changer. It's moving us in a different direction. Who's right?
Well, let me, at the risk of being wildly esoteric, say something has evolved more concretely, and that is this. You could look at most of the major cases until William and say that the upshot of the case was a process obligation. Not so much a substantive declaration of ownership as a burden placed on government to consult, to accommodate, a fiduciary duty, honor of the Crown. When you finally have the Supreme Court of Canada effectively backed into its own corner and saying, no, on this parcel of 1,700 square kilometers of British Columbia, the Aboriginal people who are claiming it, they own it. It's theirs to decide what to do with it. That is transformational in my view. But it doesn't mean that you completely displace the province's authority. In fact, the court was very clear about that. And so we have the same problem we've had for a long time. How are we going to get along together? And how are we going to find a way to create mutual benefit rather than paralysis and acrimony? And I don't doubt that paralysis is a potential outcome, but surely it's an outcome that no one should want. So let's figure out how to avoid that outcome.
But it also changes the size of the claim. Before Tsilhqot'in, you would say, well, these are reserved lands. This is the postage stamp that's yours. Right. But now we're going, in your own words, mountaintop to mountaintop. And that is a significant difference.
It absolutely is a significant difference. Aboriginal people would say it's only a difference to us white guys because we were the guys arguing that it was the postage stamp theory. They've been saying for 150 years that it was their land, and it turns out that the courts are agreeing with them. Mm-hmm. So that's fine. I mean, we could choose to make public policy going forward on the basis of what lawyers say we have to do, or we could take the better approach, which in my view is to say, let's get past the argument of the rights of ownership and past the issue of denial, past the hectare by hectare argument about whether your occupation was sufficiently intense to warrant title. And let's get to a place where we have a conversation that's more about mutual respect, mutual recognition, and creating opportunities of mutual benefit. I mean, what's changed is I think that the ground on which the people who've made the postage stamp argument have been staking their themselves for a long time, that's been swept, if not completely away, it's been swept nearly away. But we're all still here in that famous phrase, right? We're all still here together. And so we have a choice to make. Do we want to choose to make something good of it, or to run like crazy off the cliff and shout as we, crash on the rocks below, and I don't know what the heck happens. It seems to me that that's a wholly unnecessary path. And in saying that, I don't deny that I'm embracing the importance and the transformational nature. I'm not pretending that nothing important has happened.
You're not running around being scared, but you're saying we have to be aware of the fact that
We need-
this is a game changer.
This is a game changer. We need to be aware of it, and we need to figure out how to work with it to create opportunity rather than be intimidated out of opportunity.
Help me understand one thing. When the court comes along and says, you now have title to this land, does that land then fall under the definition of Indian lands, where the tax structure within Indian lands is different in non-Indian lands?
Yeah.
In other words, what is the consequence going to be to the revenue of the province?
So that's a good example of something I talked about earlier, which is one thing to comprehend the basic elements of the decision, and another to understand all of the potential implications. And so we're speaking a month or so after this decision, and I'm still trying to get my head around some of those questions. Tax advantages are a creature of the Indian Act. They exist for and on Indian reserves. Aboriginal title land is not an Indian reserve under the Indian Act. So the effect of the decision does not create tax havens on what we used to think of as Crown lands in British Columbia. Whether those arrangements can be negotiated in treaty processes or elsewhere is a good question. But the decision didn't automatically create a tax haven. When you say, though, that land is owned by a First Nation and that includes the right to create economic value from the land, then you do have to ask, what's the limit of economic value that can be created from the development of resources on land, and who should get the benefit of that? And I think, in pretty simple terms, the people who invest risk capital in creating the economic value need a return on that investment, or they're not going to risk their capital. So that leaves whatever is left over to be divided. And I do think there's a pretty good chance that the historic allocation of that benefit to the government of British Columbia is going to have to change. And Aboriginal people are going to have to share more directly and significantly in the value of the lands.
And that will have a direct impact on the revenue that goes into the provincial budget.
Yes.
So we are going to see a shift.
Yes, I think that it could, over time, develop into a pretty big shift.
Mm-hmm. Under that model, let's say you're the Tsilhqot'in now, do you come back and say, okay, good, now we understand where we're going, but there's still a few past wrongs that need to be righted. For instance, we didn't get any of that economic benefit for the last 150 years. You owe us.
Right. And there have been First Nations who've made that demand, and there are First Nations who will make that demand. For a long time, my own personal perspective on that has been, if you approach that question from a purely logical perspective, you're almost certainly going to get to a number that's too big. Mm-hmm. So we're going to have to find another answer to that.
So what is the answer? Really, we have to figure out a way to work together.
I think that's the only path forward.
Like, reconciliation has to happen.
I think reconciliation is both the sort of obligation that is created by a world of which this decision takes effect, but it's also the opportunity.
How do we do it, though, when we look at the number of processes that have been happening over the past few decades that have gone virtually nowhere? How do we go? Where do we go from here? Do we now hand it all over to the court and say, you decide?
Yeah, that's a great question. So I think the courts have done their job. It's actually now up to us to figure out how to create the relationships, enter into the arrangements, create the opportunities. I think the time of asking courts to lead the way here and doing what they force us to do should have passed. If we can't make that happen, then I'm going to be disappointed. I think our future is still in our collective hands, so we need to figure out what do we have to do to reinvigorate the treaty process, to make it more workable for those First Nations who want that kind of comprehensive resolution. What do we do with resource revenue sharing arrangements in the cases and places where that works? What can we do to more effectively ensure that revenues are available and accountability exists around the delivery of social and welfare programs? What is going to make that very challenging in British Columbia is there's over 200 First Nations, and each band, each community believes itself to be the rights holder, believes itself to be in charge of its own destiny. And for government, that's a lot of negotiations to have to think about undertaking. So government and First Nations need to see if there are ways to create frameworks for more efficient negotiations. But it's hard. It's going to be hard work, no doubt about it.
It gets muddied by the fact that we're talking about taking what have been over the last 100 years classified as provincial crown lands and dealing with First Nations that fall under the Federal Indian Act and saying, well, where do the feds get involved? Where does the province get involved? Now, also, where does the individual band get involved? How do we sort this out?
Right. Well,
Because you got one layered upon the other.
One of the things that the Supreme Court of Canada did that I would say was a step in the direction of new law, but hugely helpful from the perspective of sorting out competing jurisdictions, is they made it very clear that the province actually does have continuing legislative authority, the continuing authority over resource and land management and development. So the province can go back onto Crown lands and say, we now have to figure out how to work within a regime where Aboriginal ownership is a reality. But we don't necessarily have to call up the federal government for permission when we do that. And so I feel that the legal upshot of the court case is not wholly problematic in that regard. There is, though, an opportunity to get the feds more directly engaged, to call upon them to make good on their historic responsibility, which is their constitutional responsibility, the primary responsibility, and say, if you want to help us all make a stronger province, a stronger country, you've got to play a part here too. One thing that's never been talked about in the treaty process as much as I wish it had is the treaty process in British Columbia, which has been hugely challenging, is founded on a cost-sharing agreement between the province and the federal government. That's the basis upon which the province said, okay, we'll sit down with First Nations. Here's how we're going to divide up the responsibility. In simple terms, feds brings the money to the table and the province bring the land. If you look at all the treaty tables and ask yourself what would happen if they all concluded agreements within the next 2 or 3 years, what would happen in terms of federal cash coming to British Columbia? The answer is hundreds of millions of dollars, if not billions of dollars. And that's an opportunity which we have available to us, which I don't know, I don't know why we don't get it. It's there for our benefit and really
It could be reinvested.
And that money doesn't disappear when you bring it to British Columbia. One of my favorite stories about the impact of the Nisga'a deal is a story not about asking whether self-government's working for the Nisga'a or how resource development is working. It's about going to talk to the people who own stores in Terrace, 2 hours drive down the road, and asking them, so how's the grocery shopping going in Terrace? And the answer, at least the answer I've heard is, ever since that deal was done, they come down and they buy their groceries. They've got money to spend. They're building the community. Admittedly, New Hampshire is a long drive from Terrace, but Terrace is the biggest, big town. That's just a small example. You bring hundreds of millions of dollars of federal money into British Columbia in order to help address these issues. It will get spread around for all our benefits.
And I recognize that it's important to acknowledged the fact that yes, the Supreme Court may have said to Tsilhqot'in, okay, you have title, but it also limited who they can extinguish title to. It can only go back to the Crown.
Right.
If they choose to extinguish title.
Right. That's an ancient principle, if you will, of Aboriginal law in North America, is that the First Nations can only surrender or relinquish their title by way of surrender to the Crown. That's a principle adopted largely to protect Aboriginal people from giving away their birthright. But you're right, it's, that principle necessarily interposes an intermediary into any discussion about creating economic value from Aboriginal land. Aboriginal people can't just talk to the company. Government has to be at that table.
The current Minister of Aboriginal Affairs and Reconciliation is John Rustad, and he says nobody has a crystal ball. But if you're looking at the future right now, what's it look like over the next 5 to 10 years here in British Columbia as far as economic development is concerned? From your perspective.
Oh, I was going to say, what does he say?
No, from your perspective. He's saying nobody knows.
Oh, well.
And I think that he's hopeful that it's
number.
Yeah, I think he's hopeful that it's going to that things are going to keep moving forward.
So the pathway forward requires the provincial government to be a leader in terms of offering pathways towards reconciliation rather than towards the cliff. But it also involves creative, nimble, thoughtful private enterprise to realize that engagement is the key to success, and it involves First Nations willing to recognize that creating economic opportunity is much easier in partnership than it is in isolation, and that creating social and better social health outcomes for their communities is something we all have a stake in. You need to have all those places, all those things in alignment in order to maximize the chance for success. But I believe that you could find that alignment if you work for it.
Are you optimistic about
Well, I choose to be an optimist because I believe there is opportunity. And I think that if we choose some other path, then, I mean, we're all going to regret it. And frankly, the other path is a path away from opportunity. So who would choose that? I don't think we should deny the transformative nature of what's taken place. But I do strongly believe that we can create something from it. And we shouldn't be afraid of that.
So we need to have our eyes wide open and adjust our thinking and moderate our behavior accordingly.
That's good.
Yeah.
Nicely put.
Thank you very much.
Yeah.